Thanks very much.
So I'll just asking you about the issues in relation to the engagement of service providers. So effectively, if you are a board, does the board sign off typically on material service providers? So I won't give you hypotheticals. I'll give you a real example. In the case of an RSC, a super fund, if they're engaging an investment manager or an insurer or an administrator, is that a judgment of the board?
Well, I'd have to come back to you on that, Senator.
Okay. Surely if a fund was making a decision to engage a life insurer and it had a large MySuper portfolio, I would imagine that would be a material judgment for that fund, would it not?
Yeah, I would have thought there's all sorts of outsourcing that happens in a fund or an insurer or a bank, from little outsourcing to major decisions, as you say. And the more significant the decision, the more the involvement of the board, I would have thought.
Okay. So let's just go back to the sort of the internal audit function issue. So when you look to perform compliance checks with the prudential standards, do you ask for a risk and control matrix?
Can you comment on that?
Senator, can I ask you if you could give me a bit more specificity to your question?
Well, of course I can. If I go to SPS 510 governance, and I look at the internal audit section, which sets out, and I'll read into the record, an RSC licensee must have an independent and adequately resourced internal audit function. Okay, so they must have an internal audit function. Does that mean they can get an internal audit function from their internal resources, or do they need to bring in an external body to do that?
So funds have a choice as to whether they have an internal audit function or they outsource that.
Okay. And so they'll go through and they'll look at their risks and their controls.
But the internal audit function, yes.
Yeah. Okay. That's as I imagine it would be. And then what do you seek? Because then your prudential standard goes on to say the objectives of the internal audit function must include the evaluation of the adequacy and the effectiveness of the financial and risk management framework of the RSC licensee. So when I did an internal audit, that was a risk and control framework. It wasn't very exciting, but it was a good way to catalogue all the different risks. So would you ask for that?
So in a supervision engagement where we're focusing on risk and compliance capability, we would ask for a range of things from an entity. That would include frameworks, policies, examples of risk and compliance matrices, controls testing, a range of things we would test to determine whether the risk and control frameworks are adequate and in line with our expectations.
Okay, so do you stress test them all on some sort of a cycle?
So we don't replicate an internal audit function, Senator. What we do is we would usually pick a particular scenario and run it through a risk and control scenario with an entity in order to test the strength and resilience of the frameworks.
And what do you do for the super funds that have group insurance as a service provider? What sort of tests do you put them through from a prudential point of view?
So the kinds of, so I can't be specific, I can be general in terms of what we would do.
Okay.
So we would look at whether the entity had clarity on end-to-end processes, whether the entity was clear what controls are in place to manage the risks inherent in the end-to-end process, regardless of who performed the steps in that end-to-end process. So that would be the kind of engagement that we would undertake.
Okay. And there is a prudential standard for insurance, isn't there?
There is.
For group insurance?
There is.
Okay. And does that include obligations for the board to appoint a group insurer? Or is it more operational than that?
It's more operational.
More operational than that. Okay. So do you have a view on so-called profit-sharing arrangements that sometimes happen between the group insurer and the super fund?
I'm not aware that we do, Senator.
So you don't, it's not something that's captured by the standards?
No.
Okay, so but if there was a profit-sharing arrangement, and I'll explain it for the record, so profit-sharing arrangement might be a case where the super trustee has an arrangement with the insurer where if there are fewer claims paid by that super fund, then there is a financial benefit to the super fund itself. So that's not something that you manage in this standard making process.
So it wouldn't be covered in the standard that you're referring to. I absolutely would expect it to be covered under an entity's obligations in terms of the best financial interests of members.
Is this something that you think happens in the Australian market?
I don't know if I can answer that question, Senator. I'm not aware of it happening.
Well, you don't have that many options at estimates. You either say you don't know or you take it on notice, or you give the answer.
Sorry, Senator.
Sorry.
I'll take it on notice.
You take it on notice. So you're not sure whether...
I'm not sure.
You're not aware of that, Mr Lonzo, either?
Well, as I said, Senator, we'll take it on notice.
Okay, that's fair enough. I want to take you to this. Are you across, I'm sure you must be in a broader sense, these issues to do with Section 56 of the SIS Act?
Well, I'm aware of the issue, Senator, so I'll do my best.
Yeah, okay. How many times has APRA provided friend of the court services to superannuation funds that have sought to change their trust deeds?
Well, that's a very specific question, Senator, in terms of the numbers. What I can tell you is that there have been a number of court cases, 15 I'm aware of.
15?
Well, 15 in total that I'm aware of, state court cases. I would have to come back to you on how many of those we acted as a friend of the court in.
Okay. And what exactly did APRA do when these funds were changing their trust deeds? Or seeking to change it, sorry, I should be accurate, seeking to change their trust deeds so that they could pass on future regulatory fines to their members?
So my understanding of the broad sequence, Senator, is that there were amendments, Section 56 and 57
yes.
In 2020. So this is 4 years ago. Start date was deferred a year to
That's
2022. Right. During that time, various funds explored the idea of charging a fee to set up a reserve and sought various state courts' views on whether they could do that. In terms of what APRA was doing,
Sorry, how many funds did it?
Well, I can't give you the number of funds.
18, did you say?
No, I didn't give a number.
You didn't give a number?
No. I said a number of funds. If you'd like a number, then we can see whether we have a number.
I thought you said 15 before. Did you not?
There were 15 cases that I'm aware of. 15 cases.
Well, 15 cases of funds seeking to change their trust deeds.
Yes, that I'm aware of. APRA formed a view. APRA asked itself the question whether the behaviour of the funds in seeking the amendments was consistent with the new provisions under the SIS Act, and came to the view that they were not inconsistent. During the... And by the way, that seems to also have been the view by 4 Supreme Courts in New South Wales, Victoria, Queensland and South Australia. As you pointed out at the beginning of your question, APRA played a role as a friend of the court and my understanding is that involved providing the court with context, information, particularly around the operation of the BFID prudential policy that assisted the court, we believe, in forming its view.
And the view was that it wasn't inconsistent with the Commonwealth statute on superannuation. That was effectively what you put forward as a friend of the court, is it not?
That's my understanding, Senator.
Yeah.
Correct.
So effectively now, those judgments now have cascaded to a position where there are going to be large fines levied on major super funds, it is the members that will pay, not the shareholder organisations. So that was a very consequential period where those trust deeds were changed, and I guess that takes me to my next question, which is how big are the reserves which are currently held by the super funds as a result of being able to change their trust deeds and then collectively charge their members?
Are you talking in total, Senator, when you say how big?
What is the total value of the reserves now, which are held by the funds, which can be used to pay future fines?
Well, I don't have that figure in front of me, Senator.
Okay. Well,
if you would like us to take it on notice, I'm happy to take it on notice.
I think it's very relevant to the current debate, so I'd be grateful. What happens then, Mr Lonsdale, if the reserves that have been built up by a super fund, could be CBUS, could be any fund, are not sufficient to meet the regulatory fine? So if they have, for example, a reserve of $5 million, but the federal court awards ASIC a $50 million fine for CBUS not paying their insurance policies, for example, what happens in that case?
So I want to be careful, Senator, that I'm not drawing parallels to live cases. It's very important.
I'm just giving you examples.
And you are raising, in a sense, a hypothetical issue. But if I can answer the question this way, one of the primary motivations, as I understood it, from the funds in seeking to raise fees to create a reserve was that the inability to pay a fine or a penalty could result in insolvency of the fund, which would be very detrimental to the members' best interests. And so I think that was the primary motivation behind the events of the creation of the reserves.
But that is on the basis that there was no effort to take the money from the shareholders. The organisations which own the funds have not made any contributions to these reserves. These reserves have been built up by the members of the funds through paying higher fees, hence the amount of public interest in it. So I guess my question is, what happens if the reserves are insufficient now? You say it's a hypothetical, but perhaps you could take on notice what might happen if the reserves are insufficient. And then I guess I'm interested in what APRA is doing to assess the adequacy of these reserves given the slew of cases which are before some of these funds.
Well, I think I've answered the first part of your question, but I'm happy to take the second part on notice, Senator.
Take it on notice. Okay. Now, I know that the Chair wants me to stop, but I do